to move to one other area. You've been fairly critical of Justice Scalia's criticism of the use of foreign law in making decisions. And I would like for you to cite for me, either in the Constitution or in the oath that you took, outside of treaties, the authority that you can have to utilize foreign law in deciding cases in the courts of law in this country.
I have actually agreed with Justice Scalia and Thomas on the point that one has to be very cautious, even in using foreign law with respect to the things American law permits you to. And that's in treaty interpretation or in conflicts of law, because it's a different system of law.
But I accepted that out. I said outside of those.
Well,
in other areas where you will sit in judgment, can you cite for me the authority, either given in your oath or the Constitution, that allows you to utilize laws outside of this country to make the decisions about laws inside this country?
My speech and my record on this issue, because I've never used it to interpret the Constitution or to interpret American statutes, is that there is none. My speech has made that very clear.
So you stand by the same. There is no authority for a Supreme Court justice to utilize foreign law in terms of making decisions based on the Constitution or statutes.
Unless the statute requires you or directs you to look at foreign law, and some do, by the way, the answer is no. Foreign law cannot be used as a holding or a precedent or to bind or to influence the outcome of a legal decision interpreting the Constitution or American law that doesn't direct you to that law.
Well, let me give you one of your quotes. To suggest to anyone that you can outlaw the use of foreign or international law is a sentiment that's based on a fundamental misunderstanding. What you would be asking American judges to do is to close their mind to good ideas. Nothing in the American legal system prevents us from considering those ideas. We don't want judges to have closed minds, just as much as we don't want judges to consider legislation and foreign law that's developed through bodies, elected bodies outside of this country, to influence what, and either rightly so or wrongly so, against what the elected representatives and Constitution of this country says. So would you kindly explain the difference that I perceive in both this statement versus the way you just answered?
There is none. If you look at my speech, you'll see that repeatedly I pointed out both that the American legal system was structured not to use foreign law. It repeatedly underscored that foreign law could not be used as a holding, as precedent, or to interpret the Constitution or the statutes. What I pointed out to in that speech is that there's a public misunderstanding of the word use and what I was talking about. One doesn't use those things in the sense of coming to a legal conclusion in a case. What judges do, and I cited Justice Ginsburg, is educate themselves. They build up a story of knowledge about legal thinking, about approaches that one might consider, but that's just thinking. It's an academic discussion when you're talking about thinking about ideas than it is how most people think about the citation of foreign law in a decision. They assume that if there's a citation to foreign law, that's driving the conclusion. In my experience, when I've seen other judges cite to foreign law, they're not using it to drive the conclusion. They're using just to point something out about a comparison between American law or foreign law, but they're not using it in the sense of compelling a result.
I'm not sure I agree with that on certain 8th Amendment and 14th Amendment cases. Let me Let me go to another area. I have just a short period of time. Do you feel, it's been said that we should worry about what other people think about us in terms of how we interpret our own law? And I'm paraphrasing not very well, I believe. Is it important that we look good to people outside of this country, or is it more important that we have a jurisprudence that is defined correctly and followed correctly according to our Constitution, and whatever the results may be, it's our result rather than a politically correct result that might please other people in the world?
We don't render decisions to please the home crowd or any other crowd. I know that because I've heard speeches by a number of justices that in the past, justices have indicated that the Supreme Court hasn't taken many treaty cases, and that maybe it should think about doing that because we're not participating in the discussion among countries on treaty provisions that are ambiguous. That may be a consideration to some justices. Some have expressed that as a consideration. My point is, you don't rule to please any crowd. You rule to get the law right under its terms.
All right, thank you. Thank you, Mr. Chairman.